Hi, I'm Judge Dale Wells, and I'm going to talk to you for a couple of hours actually about California protective orders. There are actually 9 kinds of protective orders available in California. We're going to break this into 2 sessions. In the first session, we're going to talk about the protective orders that people normally think of. Things like emergency protective orders, we call them EPOs, or domestic violence restraining orders, we call them DVROs, or civil harassment restraining orders, that's CHROS. Those are the 3 that most people think of when they think about protective orders, but there are actually several others. And in our second session, we'll talk about things like workplace violence and school violence and gun violence and juvenile dependency and delinquency restraining orders, elder abuse, criminal protective orders, and then we'll wrap it up by talking about how they are enforced. What is the priority for enforcement? Well, why do I think it's important for you to know this as minors counsel? Well, it's important for you to understand, especially in light of some of the things going on these days, school violence and gun violence, things like that, juvenile protective orders. Those things could very easily cross over into your area of representing minors as minors counsel appointed by the court. So that's the way we're going to break down these 2 sessions. Now, the first thing people are aware of is things like emergency protective orders. These typically begin with a phone call by law enforcement. Law enforcement calls the magistrate, that's the judge who has the duty for dealing with things like search warrants and arrest warrants and things like that overnight. And so law enforcement calls the magistrate, and they may call it any time of day or night, 24/7. But generally we're talking about in the middle of the night, and they call, and the officer reports that he was called to the scene of some kind of violence. And he tells what he was told at the scene and what he observed at the scene. And the officer requests an emergency protective order from the magistrate. Now, it's up to the magistrate whether to grant the protective order or not. If the magistrate grants that protective order, the emergency protective order takes precedence over any other protective orders in any other case. Now, oftentimes, the person who's accused of the violence has fled the scene. They know they're going to get in trouble and they've taken off. But sometimes that person may have been detained at the scene. Well, emergency protective orders are kind of a spur-of-the-moment type of order given by a magistrate to law enforcement late at night or actually any time violence takes place. In order to get an emergency protective order, the officer has to give the magistrate reasonable grounds to believe that there is immediate and present danger of domestic violence, child abuse or abduction, elder abuse or dependent abuse, or stalking, or reasonable grounds to believe that there is a demonstrated threat to campus safety, and that an emergency protective order is necessary to prevent the occurrence or recurrence of domestic violence or child abuse or abduction or elder or dependent abuse or stalking or a threat to campus safety. So the grounds that the officer alleges, based upon what he or she has observed at the scene, is that there's an immediate and present danger of domestic violence. There's an example. Based upon an allegation of recent abuse or a threat of abuse. Now, as we go through these scenarios, and I talk about the various protective orders in both this session and the next, I've given you all of the law and all of the statutes that relate to each of the orders that I'm describing. Well, domestic violence is the one that we normally think of when we think of an emergency protective order. It could be child abuse by a family or household member based upon an allegation that there's been some recent abuse or that there's a threat of abuse. Or it could be child abduction by a parent or relative based on a reasonable belief that a person has intent to abduct or flee the jurisdiction, or on an allegation of a recent threat. Now notice these have to do with reasonable beliefs. There has to be some basis in reason for the orders that are being requested. There has to be some basis in reason to believe that there is that immediate and present danger. Or elder and dependent abuse. That's based on the allegation of recent abuse or a threat. But if elder abuse is only because of financial abuse, someone's misusing the money of the older person, you can't get an emergency protective order for that. Or it could be that there is an immediate and present danger of stalking based on the allegation that this person has been willfully, maliciously, and repeatedly followed or harassed by another person who has made a credible threat with the intent to put that person in reasonable fear for his or her safety or the safety of an immediate family. Or it could be that a school or campus peace officer might assert reasonable grounds to believe that there's a demonstrated threat to campus safety. That's something that, unfortunately, is more and more likely these days. But that only exists if there's a memorandum of understanding in place between the school and the local police jurisdiction. Now, in order to get an emergency protective order based on domestic violence, there has to be a particular kind of relationship that exists between the party who perpetrated or allegedly perpetrated the violence and the party who is the alleged victim of the violence. It could be that it's a spouse or former spouse, or it could be a cohabitant or a former cohabitant. And that is described by Family Code 6209. We'll talk about that a little bit later. What does it mean to be a cohabitant? But notice in each of these, it's a spouse or former spouse, a cohabitant or a former cohabitant. So if the relationship exists now, that qualifies. But if the relationship existed in the past, it also qualifies. It could be a dating or engagement or relationship, either current or past, as defined in Family Code 6210. And again, we'll talk in more detail about what's involved in a dating or engagement relationship. Or it could be a party with whom a person has a child, where the male parent is presumed by the Uniform Parentage Act, that's Family Code 7600 et sec, to be the parent. Now that's important, especially these days when so many people have children together but they're not married. And maybe the person who's the male parent, or we think might be the male parent, never did step up and claim to be the male parent, or that person never did sign a voluntary declaration of paternity, or has never been adjudicated to be a parent. In other words, just because a person thinks he's the father, that doesn't make him the father. Just because the mother thinks this person's the father doesn't make him the father. That's what's governed by Family Code 7600 et sec. Or it could be that the relationship for a domestic violence restraining order is that of a child or a party or a child subject to a parentage action where that presumption of parentage applies that I just alluded to a moment ago. Or it could be a person related by consanguinity. Now that's one weird word. Consanguinity means related by blood. Or affinity, which means related by marriage to the second degree. Now what that means is that domestic violence restraining orders, or EPOs based on domestic violence restraining orders, can only apply to parents, grandparents, siblings, children, or their spouses. In other words, the spouses of the parents, the spouses of grandparents, the spouses of siblings, the spouses of children. Nobody else. Notice, cousins are not listed there. Well, who can be protected? Well, protection can be provided to a lot of people. It could be the person and the children who are in danger. But notice the fact that the endangered person may have left the household to avoid abuse does not affect the availability of an emergency protective order. What does that mean? Well, that means that suppose there was some domestic violence that took place in a home. And in order to escape the domestic violence, the person who was the victim fled the residence in order to escape the violence. The fact that they fled the residence doesn't mean they cannot get a restraining order. Well, what kind of orders can you get as an emergency protective order? Well, there are orders called personal conduct orders. They're defined in places like Family Code 6252A and 6218A and 6320. And those are basically what I call be nice orders. You can get orders for exclusive care of and protection of animals. You can get orders to make someone stay away from another person. You can get orders kicking a person out of a residence, even if they have a right to be in that residence, or even if they have an ownership interest in that residence. You can get an order for temporary care and control of a child of an endangered party and a restrained party. and you can get orders for temporary care or control of an endangered child or other children in the family or household with the parent or guardian of the endangered child. So, for example, if a couple is living together and he has some kids and she has some kids, and maybe they have some kids together, but there is domestic violence that's perpetrated by one party or the other, you can actually allow the children to stay with the party they're not related to on a temporary basis under an emergency protective order. Other orders you can get are things like temporary care and control of a child who's in danger of abduction. Or, in the case of elders and dependent adult abuse, you can get orders to protect elders or dependent adults. And along with these orders, you can get an order that says that the person who's restrained cannot get the address or location of the protected party or their family members or their caretakers or guardians. And normally that's going to be an order that's made unless the court finds good cause not to make that order. So you can see that an emergency protective order is the kind of an order that provides broad protection, but it doesn't provide it for a very long time. In fact, the emergency protective order will expire at the earlier of the close of business on the 5th court day after issuance or the 7th calendar day following the day of issuance. Now, what does that mean? That means, for example, if an emergency protective order is granted the Friday before Thanksgiving, that order would expire the following Friday, even though there are only 3 judicial business days in between, which are Monday, Tuesday, and Wednesday. So just because it could be 5 court days or 7 calendar days, it's whichever of those 2 periods is the shorter. Now, police are required to personally serve the respondent if they can locate them, and to give a copy to the protected party so that that protected party can prove that they have this restraining order. And law enforcement is required to enter that restraining order or that emergency protective order into the Department of Justice database within 24 hours. Well, that's an emergency protective order. But what can the person who receives an emergency protective order do if they need an order that lasts longer than that 5 to 7 days? Well, if the order is based upon the allegation of domestic violence, they can come to court to get a domestic violence protection order, a DVPA, under the Domestic Violence Prevention Act. Now, the purpose of a domestic violence prevention order is to prevent domestic violence and to provide for a separation for a period of time sufficient to enable the parties to seek a resolution of the causes of the violence. But the court need not believe that there is a possibility of future abuse in order to grant a restraining order. In other words, even if the court doesn't think there's a likelihood of future abuse, they can still grant the restraining order. Well, what's the burden of proof? Well, here we get into some abbreviations that might be interesting for you, might be helpful for you. One is a TRO. That's a temporary restraining order. You're going to see throughout these slides references to TROs. A TRO is an order that's given for a short period of time, longer than the 5 to 7 days, but it's based upon a reasonable proof of a past act or acts of abuse. Now, after a person obtains a TRO, they have to provide a service to the other party, the accused party, the restrained party, of the documents that they filed, so that that person has an opportunity to show up in court and provide a response to it. Then the court can grant an order after hearing. That's an OAH. Now, the difference between the burden of proof is pretty substantial. A temporary restraining order is based upon what we call the probable cause standard. Reasonable proof of a past act or acts of abuse. You don't have to have strong proof, just kind of a belief that something improper might be going on here. But the order after hearing requires a higher level of proof. That preponderance of evidence, which is the basic standard of evidentiary proof that's required for most cases, really. The preponderance of evidence basically means it's more likely than not that this happened. Now, in order to renew an order at the end of a permanent restraining order, that was that OAH, in order to renew it, there has to be a preponderance of evidence that the protected party entertains a reasonable apprehension of future abuse, but that person doesn't have to show that there's been abuse since the issuance of the original order. There are a couple of things that are really worth noting there, and that is, it's not enough for the protected party to have an unreasonable apprehension of future abuse, and it's not necessary that there have been further abuse since the issuance of the original order. It's enough only if the person has a reasonable apprehension of future abuse, whether or not there has been further abuse since the issuance of the original order. Of course, it makes it easier for the court. If there has been further abuse since the original order was issued, then the court can pretty easily say, yeah, we need to renew this order. But if that party wanting the renewal has an unreasonable fear, that's a pretty difficult test to apply. An unreasonable apprehension of future abuse. Would a reasonable person, under these circumstances, entertain the idea that abuse might happen once the restraining order expires? That's what the court's looking for. Well, what is abuse? It's defined in Family Code 6203. Intentionally or recklessly causing or attempting to cause bodily injury or sexual assault or to place a person in a reasonable apprehension of an immediate serious bodily injury to that person or to another, or Family Code Section 6320A behavior. This is what I commonly call the Be Nice orders. The kind of orders that can be enjoined under a restraining order, like do not molest, attack, strike, stalk, threaten, sexually assault, batter, credibly impersonate another person, falsely personate another person, harass them, telephone them, including but not limited to annoying telephone calls, destroy personal property, contact them directly or indirectly by mail or otherwise, come within a specified distance, typically we'll say 100 yards, or, and this is kind of a catch-all that you'll see used a lot, disturbing the peace. Well, if you want to know what those things mean, you can find them in other statutes. Stalking, for example, is defined in Penal Code Section 646.9. Credibly impersonating someone is described in Penal Code Section 528.5. Falsely personating someone is described in Penal Code Section 529. Harassing them by phone, well, that's described in Penal Code Section 653M. And disturbing the peace, well, there are some cases on that. There's In Re Marriage of Nadkarni, which talks about hacking email. There's Evil Sizer and Sweeney, which talks about disseminating information from a personal journal or an ISP or social media. There's Altafula versus Irvin, which has to do with sharing personal information with someone's family and employer. That kind of thing. That kind of thing that would disturb a normal person's peace. But in order to get a domestic violence restraining order, there has to be a particular kind of relationship, and that relationship is defined in Family Code Section 6211. It can only be gotten for a spouse or former spouse, or a cohabitant or a former cohabitant, or a dating or engagement partner, either present or former, or a party with whom that person has a child where the male parent is presumed by the law, the Uniform Parentage Act, to be the parent of the child, where the child of the party, or it can be obtained for the child of the party or a child subject to the Uniform Parentage Action, where that presumption applies, or it can be gotten regarding a person related by consanguinity or affinity, that's blood or marriage, to the second degree, parents, grandparents, siblings, children, and their spouses. Well, some of those words have definitions that may not be the ones we would normally use. Cohabitant, for example, Family Code 6209. Well, a cohabitant is a person who regularly resides in a household, a social unit. We're not talking about roommates or sublessees. We're not talking about 2 or 3 people who decided to rent an apartment together or a condo together, and then they have a falling out. but all they're doing is living in the same premises and sharing space and sharing rent. That's not what we're talking about. We're talking about the kind of relationship so that people think of them as a social unit, not just roommates or sublessees. Dating relationship, what does that mean? Well, it's defined in the case of Oriola versus Thaler. It has to do with frequent intimate association characterized by the expectation of affection or sexual involvement independent of financial considerations. In other words, it has to be a serious courtship. It has to have been going on for a period of time. It doesn't have to be a long time, but it has to be some kind of a period of time. So the person who goes out for a single date probably doesn't qualify. And since it says independent of financial considerations, certainly the person that's picked up as a streetwalker doesn't qualify. In order to understand these relationships, it's important to look at not only the statutes but also the cases. For example, a father and a stepfather do not have the required relationship for a domestic violence restraining order. Including the child doesn't provide a nexus to confer jurisdiction. So imagine this situation. There's dad and there's stepdad. And people might think that because they're both connected to that child so that a restraining order could impact that relationship that each of those men has with the child. That doesn't mean that they have that relationship with each other. Father can't get a restraining order against stepdad, and stepdad can't get a restraining order against father under the Domestic Violence Prevention Act. Another thing that you need to consider is for a domestic violence restraining order request from the mother based on the father's abuse of the child, you have to consider things like, does the mother have firsthand knowledge of the conduct, or is this something the child has related to her? So is she a competent person to testify to the behavior? Consider then if the abuse placed the mother in a reasonable apprehension of imminent, serious bodily injury to herself or the child, or if it disturbed her peace. This can be a very tricky consideration, because many times you'll find that mom, for example, will want to file a restraining order in the child's name against dad, but mom has no way of knowing exactly what happened because it's only what the child has reported to her. Well, who can be protected? The petitioner can be protected for good cause. Other family members can be protected. But here's something you need to know, and especially as minors counsel, you'll probably want to be aware of this. For these restraining orders, a minor age 12 and older does not need a guardian ad litem to file a domestic violence restraining order. But something else you need to know is that the court cannot grant mutual restraining orders unless in court both parties personally appear, both parties present written evidence of abuse. That means that the respondent has to file his or her own request for protection under the Domestic Violence Prevention Act, and the court has to make detailed findings of fact that both acted primarily as aggressors and neither acted primarily in self-defense. Way back when I was engaged in private practice, it was a fairly common practice for attorneys to just write mutual restraining orders into just about every kind of marital settlement agreement. And basically, those were not enforceable. Unless law enforcement can say this person is restrained from doing this kind of behavior, they can't enforce it. And making these broad, sweeping statements of both are going to be staying away from each other, you can't do that sort of thing unless there is this specific three things that are found. Both parties personally appearing in court, both presenting written evidence of abuse by the other one, and the court has to make detailed findings of fact that both acted primarily as aggressors and neither acted primarily in self-defense. Well, what kind of orders can you get? Temporary restraining orders that are available include things like personal conduct, no contact, stay away orders, orders protecting pets, orders that say who's going to care for the pet and that one person has to stay away from the pet, and personal conduct toward the animals. residence exclusion with Domestic Violence Prevention Act, actually the person who owns the house or the person who is the lessee of the house can actually be kicked out of their own house in favor of another person who's living there and had been living there with their consent prior to the domestic violence. Other restraints that are necessary to effectuate the court's order. In other words, the court can make up other orders that would assist in enforcing the basic orders under the domestic violence restraining order. Orders for the restrained party not to get the address or location of the protected party. Orders granting temporary custody and visitation of a child where the father is a presumed parent or has been adjudicated to be a parent of the child. But the court can make a finding of parentage by stipulation, subject to a set-aside at a later time in order to make temporary custody and visitation orders. There can be orders about temporary use, possession of real property and personal property, specified acts regarding community or separate property, orders to prevent the parties from making changes to insurance policies, and orders that apply to all restraining orders about firearms and ammunition. Firearms and ammunition cannot be owned or possessed, or the person who's restrained cannot even have access to firearms or ammunition. And they have to turn any firearms and ammunition over to law enforcement. They have to sell them or store them with a licensed gun dealer. They have to, those are the only options that they have. Either store them or sell them, or store them with a licensed gun dealer, sell them to a licensed gun dealer, or turn them over to law enforcement. Now, after a hearing, the court can grant all of those orders that we've just gone over, but they can also make child support without prejudice, spousal support without prejudice, orders for restitution. In other words, the petitioner may need restitution for loss of earnings or out-of-pocket costs as a result of the domestic violence. The respondent, if the respondent prevails, may be entitled to costs if they prevail at the hearing. And if an agency has provided costs of services to the petitioner, they're entitled to reimbursement. But there is no provision for restitution for pain and suffering. One thing you'll often see happen with domestic violence restraining orders is that the court will order a batterer's intervention program. And if they make that order, it has to be a 52-week program. It cannot be a lesser period of time. And then the prevailing party can, of course, get attorney's fees and costs by court order. The court also can transfer the billing responsibility for and rights to a cell phone to the protected party. So how long do these orders last? Well, the temporary restraining order, that's the one that's gotten on an ex parte basis, where one person comes in and files paperwork that says, this is the abuse that I've been suffering. The judge looks at it. The judge believes that the person's made a good enough case to get that temporary restraining order. The temporary restraining order can last for 21 days, or if the court finds good cause, as much as 25 days, and that's calendar days. But orders for custody, visitation, and when you get to permanent orders, support, survive the termination of the temporary restraining order. The order after hearing, on the other hand, cannot last more than 5 years for protective orders and firearms, but custody, support, and visitation orders survive the expiration of the domestic violence restraining order. If the order doesn't state how long it lasts, it'll be 3 years. So up to 5 years, but if the order is silent, it's 3 years. If someone comes to court trying to renew that restraining order at the end of that period of time, the order can be renewed for 5 years or permanently, and it has to be filed within 3 months before the expiration of the order. If the court denies a request for a restraining order, after hearing, the court has to provide a brief statement of reasons for a decision in writing or on the record. Well, what kind of due process are we talking about for such an order as a domestic violence restraining order? Well, there's a certain notice requirement. For a temporary restraining order, once the protected person gets that temporary restraining order, they have to get the restrained person served personally at least 5 days before the hearing. The respondent, if the respondent chooses to do so, may file a response explaining or denying at least 2 days before the hearing, and those are calendar days, not court days. When it comes time to renew the restraining order, it has to be served by personal service at least 5 days before the hearing. Now, obviously, this doesn't give a lot of time for the restrained person to respond. So, the respondent is entitled to one continuance upon request for a reasonable time in order to respond. And either party can get a continuance for good cause if they make the request in writing before the hearing or orally at the hearing or even on the court's own motion. Well, that's the basic law about domestic violence restraining orders. There's a kind of restraining order that most people think is very similar, but it has some significant differences, and that's a civil harassment protective order. You're going to see a lot of similarities between the domestic violence restraining order and the civil harassment restraining order, and you're going to see some similarities, you're going to see some differences. For example, the temporary restraining order, the burden of proof is reasonable proof of harassment by the respondent and the belief that great or irreparable harm would result to the petitioner if the temporary restraining order was not granted. The order after hearing is based upon, though, clear and convincing evidence. You see the difference there? With a domestic violence restraining order, the order after hearing is based upon a preponderance of evidence, which is just it's more likely than not that the violence took place. But for a civil harassment order, the burden of proof is called clear and convincing evidence that unlawful harassment exists. Well, what is harassment? Well, harassment is unlawful violence, which could be assault, battery, or stalking, but not self-defense or defense of others. Or it could be a credible threat of violence. In other words, a knowing and willful statement or course of conduct that would place a reasonable person in fear for himself or herself, for their immediate family, and that serves no legitimate purpose. Or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses that person, and that serves no legitimate purpose. A course of conduct, well, that's a pattern of conduct composed of a series of acts over a period of time, however short, evidencing continuity of purpose. And it's got to be conduct that would cause a reasonable person to suffer substantial emotional distress, and it must have actually caused the petitioner to suffer substantial emotional distress. Now, in the case of a civil harassment restraining order, there is no relationship requirement. Do you recall with the domestic violence restraining order that you had to have a certain kind of a relationship, a spouse or former spouse, a dating or engagement partner, either present or past? You had to have certain relationships, but there's no relationship requirement for a civil harassment order. And again, the minor, if a minor wants one, a minor age 12 or over can seek their own, but a minor under the age of 12 needs a guardian ad litem. Well, who can be protected? Well, the petitioner can be protected, and in the discretion of the court or for good cause, all of the petitioner's family or household members can be protected. And with regard to mutual orders, it's very similar. The respondent may file a cross petition for their own civil harassment restraining order. What kind of orders are available? Well, personal conduct orders, do not harass, attack, strike, threaten, those orders. No contact orders, stay away orders, but a civil harassment order does not allow for residence exclusion. You can't kick a person out of a house or apartment based upon a civil harassment restraining order. The court can fashion other restraints on behavior as necessary in order to effectuate the orders that the court makes. There can be orders about pets. Who's going to care for them? One person has to stay away from them. Personal conduct. Don't dispose of pets. Things like that. And as is always the case with all of these restraining orders, a person who is subject to a restraining order cannot own or possess firearms and has to relinquish those that are owned. Either sell them to a licensed gun dealer, store them with a licensed gun dealer, or turn them into law enforcement. And those are their only options. And the prevailing party can get attorney's fees and costs. Well, how long do these restraining orders last? Well, as with the domestic violence temporary restraining order, the temporary restraining order in a civil harassment case lasts 21 days or 25 days if the court finds good cause. The order after hearing can last not more than 5 years, but if the order is silent, it will last 3 years, just like with the domestic violence restraining order. And if a person seeks renewal, it can be renewed for not more than 5 years upon a request of a party without a showing of further harassment since the issuance of the original order, and it has to be filed within 3 months of the expiration of that order. The due process orders are similar to those in the domestic violence restraining order. It has to be personally served within 5 days, at least 5 days prior to the hearing, and the respondent may file a response. The statute is silent on how far before the hearing the respondent may file a response. It can be modified or terminated based upon personal service at least 16 court days prior to a hearing to terminate or modify the restraining order prior to the expiration date. And the respondent's entitled to one continuance for a reasonable period of time to respond, and either party can get a continuance for good cause if they request it in writing before the hearing or request it orally at the court, or if for some reason or another the court believes it's important to give a continuance. Well, that completes our review of the most commonly known protective orders: emergency protective orders, domestic violence restraining orders, and civil harassment restraining orders. In our next session, we'll look at some less commonly known protective orders, but they're orders that you might well find relevant to your work representing minors. Because in session 2, we'll talk about workplace violence, school violence, gun violence, juvenile dependency and delinquency, elder abuse, criminal protective orders, and what orders are enforced and what the priorities are in enforcement, which ones take precedence over which other ones. But that completes our first review of the main orders that people think about. I hope you'll stick around for the second view.